Hey, Kevin.
Hello, Rebecca.
Guess what we're doing?
It's a readathon.
That's right. We're here doing a readathon because today was the final pre-trial hearing before the start of the second trial of Karen Read.
Final pre-trial. Okay.
Yeah. And it was...
it's like the last spring training game.
Oh, that's a really
before
good analogy.
baseball season starts, which is actually going to coincide.
Except this isn't a game, Kevin. It's somebody's life on the line.
Jesus. Okay, yes.
Just reminding you.
Yeah, okay. No, I can't disagree.
All right, so it's a big headline. I just want to acknowledge it. We are taping before this, but Judge Beverly Cannoni today in court said that she would rule and release her ruling on the motion to dismiss by the defense by the end of the day today. And I'm pretty sure she's going to deny it because otherwise, why even have this hearing today?
Yeah.
So we're just going to go ahead and tape. Obviously, if she doesn't deny the motion to dismiss, we'll just have to tape again, but I think it will be worth it.
That seems like that would be a huge twist. Be like, in our final episode of the readathon.
Exactly.
But if she says, it kind of sounds like it's already written. So
yeah, she's
right.
also going to issue a ruling today on the buffer zone that the prosecution wants to push out from farther than it currently is.
No, I'd love to hear the arguments on both sides of that, but go right ahead. What's the big stuff?
Okay. First of all, somebody on Reddit posted this, and I don't know if you've ever seen this. Do you want to know where the name Auntie Bev comes from?
I have like something about like vacation home or what's that all about?
Yeah. Early on, Sean McCabe, who is Jen McCabe's brother-in-law, so it's Matt McCabe's brother, and Turtle Boy were in sort of like a nasty, but very Turtle Boyish text exchange.
Yeah.
And you have to understand, a lot of people early on in this case reached out to Turtle Boy to shit on him. And then he just tries to get him to say stuff and become sources. He's like, you can be a source, it's fine.
Yeah.
So during one of these exchanges, apparently Turtle Boy asked Sean McCabe, do you really have a line to Judge Cannoni? And Sean McCabe said, Auntie Bev, whose seaside cottage do you think we're going to bury your corpse under?
Huh.
So
okay.
they showed this exhibit in their argument, the defense did, in their argument for Judge Cannoni to recuse herself. This was an exhibit they showed, a giant poster with that text exchange. Anyway, so I thought you would enjoy that. That was from before the last trial.
The context is that the McCabes actually rent the cottage
that belongs
to
Judge
Cannoni
and her husband, who was Chris Albert's defense lawyer in his drunken driving killing case.
The one in which Chris Albert, brother of Brian Albert, town selectman.
Well, I think he was a cop at this time. Yeah.
Killed somebody in a drunk driving accident.
Yes.
And then promptly turned himself in.
No, he fled.
Yes.
For many weeks.
He was a fugitive. Okay. Yeah.
Really interesting.
Oh my God, we so have to do a breakdown again on all these characters.
We are. I think we're going to do a best defense witnesses and best prosecution witnesses breakdown, and then probably talk about all the Commonwealth characters.
But again, the point is that one of the McAlberts or the McCabes or what are they called together?
McAlberts.
The McAlberts.
Yes. Claims
to be that Auntie Bev is their summer vacation landlord.
Yes.
Okay.
Yes.
All right, sure.
Also, just so you know,
it's fucking town.
She is very familiar with a lot of characters in this case.
Yeah.
I mean, people have brought cases into her court. There are cops involved in this case. And of course, she's familiar with all the cops that are tied to the district attorney's office.
That's actually not very nefarious at all. Especially, this cop knew that cop.
Right.
And it's like, well, of course, it's a small town and yada, yada. I mean, that isn't the issue.
Yeah.
The issue is did you end up going out drinking and getting so drunk that you've lost your service weapon?
That's right.
And okay. Yeah, anyway.
But the thing that's interesting about that to me is that she sometimes behaves very credulously in the courtroom, and the defense feels like they need to explain who people are to her.
Right.
They don't, or they shouldn't.
Right.
Let's put it that way.
Yeah. And the one other thing I've always been kind of puzzled about Judge Cannoni about is that she has background in public defense.
Yes.
So it's not like some of these people who come up in the prosecutor's office and have never done that side of criminal law. So that they just come in and see everybody is guilty. Well, obviously, if the cops arrested them, because I always work with cops, the ones that they arrested are guilty. That can be a hard thing to get over.
Yeah.
So I sometimes wonder, where where her respect is for the defense mission.
Right.
Right. So in any event.
Well, also, as we learned, as we know, Jackson was a prosecutor for Los Angeles.
Sure, yeah.
And Yannetti was a prosecutor in Boston, a thing I learned from watching the Karen Read documentary on Max.
Right.
I'm sure I knew that before, but I had forgotten.
And the special prosecutor in the Karen Read case
is a defense attorney.
Right.
Yeah, it's really interesting dynamics.
Yeah,
One thing I just want to talk about briefly before we get started on today's hearing. We watched the 5-part Karen Read docuseries on Max. I'll just give you my thoughts on it briefly. I'd love to hear yours. I think it's actually a decent primer on the case.
Yeah.
It kind of skews down the middle, but there's a lot of stuff in there that to me was super interesting. You got the behind the scenes look at the defense case because you were in their war room with them. You saw their personal interactions with each other. And, I know a lot of free Karen Read people, FKRs as they're called, don't like the doc. They feel like down the middle is just too far to the,
yeah.
Which, I think that's fair if you're 100% sure that someone didn't do something, as I am. But at the same time, as a journalist, I can tell you, it's not as good as the Vanity Fair story, which laid out the whole case, but it wasn't anti-Karen Read. Did you think so?
No, I did not think. They followed Karen Read around. This is very much like The Staircase as far as the behind the scenes stuff. And we should talk about it at some point. I'll just say that I agree with you. I thought it was very good. A great primer. I will also say they did a good, fair job laying out the bad facts against Karen Read. And I'll tell you that my mind hasn't been swayed. But I will tell you, don't say it, because we had this discussion.
I'm pretending to be surprised.
I will say that I see reasonable doubt on both sides of this. I see like a little the prosecution case to me is stronger after seeing it presented this way. But as far as is there reasonable doubt in my mind?
Right.
There's a whole fucking lot of reasonable doubt. But okay. All right, we delayed this long enough. What happened today?
Okay, can I just say one more thing about that?
Sure, have the last word.
Terry Dunn Muir, who made the series, gave an interview to Vanity Fair that's actually out now. And she talks about trying to walk that middle line. So giving that reasonable doubt on both sides, in my mind, was her mission. So anyway, just leave it there.
Okay.
All right, so today was the final pre-trial hearing.
Right.
Now, first I need to talk about a motion that was filed by the defense today, that came out today, because this featured predominantly in the pre-trial hearing. And you remember I talked about Hank Brennan's motion to exclude the third-party culprit theory?
Right.
This was their opposition to that motion.
Okay, is this their response or is this a separate motion? Okay, all right. Gotcha.
And hoo boy, is it juicy. So it lays out the reasons why they believe Brian Albert, Brian Higgins, and Colin Albert are good third-party culprit suspects in here. And the Brian Albert section, for instance, starts with...
First line.
Brian Albert did not have a good reputation among his fellow police officers.
Fact. Or I don't know, fact.
He was known as a bully, someone with a history of sucker punching fellow officers, particularly when he was drinking.
Oh, man. Okay.
So it starts there that he's violent, known to be violent by people even in law enforcement, that he'd been heavily drinking the day in question, that it's his house.
Yep.
So he was there, that it's his dog, and that he is good friends with one of the other third-party culprits in the case. And what they also say is that there's consciousness of guilt implicating him, despite the huge police presence on his lawn. He never went outside. And keep in mind, he's a first responder. His disposal of his phone, his rehoming of Chloe. I didn't really understand the timing of this very well, okay? They say, the Alberts say they rehomed Chloe because she had gotten into a fight with another dog.
Yeah.
They rehomed Chloe immediately after the defense presented in a pretrial hearing last time their intent to have Chloe be part of this case. So before that, the dog bite thing had never been brought up in court. As soon as it was brought up in court, they rehomed Chloe, which this motion basically calls her a member of the family.
Okay.
Which we're dog people. You know what that means, right?
Sure.
And you know,
it's interesting. There was a clip. Now it's fresh in my mind because it was in the documentary about when Brian Albert was on the stand talking about Chloe. He says the reason that they got rid of the dog was because Chloe got into
it was a violent dog.
Bit another dog, got into another dog fight. So it just, it doesn't. I don't want to character assassinate Chloe, but
yeah. Chloe's
That's a
troubled.
tough bitch. Yeah.
But Chloe also had a very violent role model, apparently.
Had a bad reputation among the Boston police.
By the way, I have read the witnesses that they're going to bring in to talk about Brian Albert's violence are fellow cops, and one of them
Bring him in
one of them
willingly? Oh,
was
man.
apparently punched by, he was Brian Albert's partner, and he was punched by Brian Albert. Another piece of this motion, and I'll get to the other two guys in a second, is that the police never investigated these people properly. All right.
Okay.
That's important. And
Okay.
and we know that they didn't. There's evidence they didn't in the Proctor texts when someone said, is Brian Albert going to get caught up in this? And then Proctor responded, nope, the homeowner is a Boston cop too.
Yeah,
Okay. So basically showing that he was never investigated.
Yep. There's a big implication there that I think we all can read between the lines on that statement.
Right. Next up, Brian Higgins. Apparently also had been drinking a lot. Brian Albert, by the way, had been drinking since the day before, because the day before he went to that funeral in New York for that other cop, and all the cops went out drinking after. The night of the waterfall incident, when they all met at the waterfall, he had been at a bar before that.
Okay.
So he'd been drinking like a lot.
Okay.
So that's important to know.
I will say that I do admire the fact that he drank so much, yet was still able to perform sexually later that night.
And pocket dial.
Yes.
Pocket dial Brian Higgins.
Yes, there's a lot going on in those pants.
At 2:30 in the morning?
Yeah, man, this guy can hold his liquor.
Yeah, absolutely.
By the ears.
Oh, and by the way, he
dirty.
knew
Okay.
his sex was so good. He's so good at sex.
So good at sex.
That he knew in the moment that he had butt dialed Brian Higgins, because he had the presence of thought to get his phone wherever it was in his pocket while he was wearing his pants. I don't know. And notice he was butt dialing and then hang up the call after like 20 seconds or whatever.
Yeah, and I'm so good at sex.
I'm so good at
My
sex.
phone goes off. The power just it opens up the lock.
Right.
The screen lock.
Right.
And randomly texts people in my contacts when I'm fucking.
Right.
Jesus.
All right. So on to Brian Higgins.
Yeah, okay.
He's a third-party culprit because he had been engaging in this flirtatious relationship with Karen Read. She kissed him once at John O'Keefe's house after an NFL playoff game. I don't think anyone is not stipulating to that. And they had all these flirtatious text messages back and forth, which were read in court, as we know, because it was in the documentary. We got to experience it all over again. And then the night of the incident, Karen and John showed up together and they were being very affectionate with one another. And that Higgins was visibly annoyed, they're saying on video, which you've seen that video before. It's clear. It's not clear to us, but I guess, everyone else knows who everybody is in that video.
Yeah.
And that he kept asking John O'Keefe if he was coming to 34 Fairview. All right. He
Which also implies that he's asking whether Karen is coming.
Right. But he wanted John. It was very clear he wanted John to be there. And I have a theory about that, which, as a side note, is that he was planning on being a prick to John and blowing up his relationship or whatever. I don't think anyone was planning to murder him, but I think that was that's why he wanted to talk to him. Yeah. And then he texted Karen while at the bar. I don't know if you knew that. Do you know this?
No.
He texted Karen while at the bar.
So in the same room, he sort of
when she was with John O'Keefe.
Yeah, okay.
And she didn't reply to any of his texts. She hadn't been replying to his texts for a while.
Do we know what that text was?
Yes. It said, well...
Oh, that's what that was.
Right. So almost like he was saying to her, wait, I thought you wanted me. And here you are with him. You know what I mean?
Yeah.
So he talks about, and this motion talks about his consciousness of guilt, that he went to the Canton police station instead of going home after leaving 34 Fairview, that he said he was doing administrative work, later changed his story to having moved cars, that he denied having made any phone calls from the Canton police station, but obviously now there's video that shows he did.
Yep.
And
don't forget what he did with his phone.
The day before, he was going to get his notice about preserving his phone evidence. He knew that was coming because other people in the case had gotten theirs that day and the day before. The day before he received it, he removed his SIM card from his phone, drove to a military base to throw this tiny object into a giant dumpster.
I like how he explained that he was just driving through. He was passing through the military base.
Yeah. And by the way, that was the language in the motion. He destroyed the SIM card, then traveled to a military base to put that tiny object about the size of a thumbnail into a large dumpster.
Yeah.
I love that sentence. All right. So moving on to Colin Albert. This motion claims that he had been in a feud with John O'Keefe in the weeks and months leading up to January 29th. That he had thrown beer cans.
They were somewhat neighbors, right?
Yes. They were across the street diagonal neighbors.
Right. Okay.
John O'Keefe is across the street diagonal neighbors with Chris and Julie Albert. And what they say is the most compelling evidence against Colin, which I gotta say, it's not nothing.
Mm-hmm.
His name was not on any police reports. Police reports that, by the way, had everyone else's name of people who were at the party that night. His name was not on any of them. And did you know that a bunch of police reports referred to Brian Albert as B. Albert and had the wrong address for him? It was almost as if the police were trying to distance Brian Albert from this case.
Okay.
But Colin Albert, the only reason the defense knew Colin Albert was there was because of the federal grand jury investigation. Otherwise, he would never have been there.
Like when people talk about a conspiracy, it's like, well, okay, it's one thing among a bunch of mobsters or whatever. These are family members.
Right.
So the idea that like hanging together is more important than if it's like 12 of my buddies.
Right.
Yeah. And so the implication is that when the police talked to all the individuals and people said, who was there? Either Colin's presence was so unmemorable that everybody forgot.
Doubt that.
Or it certainly looks like they were intentionally trying to withhold the fact that of all the people who were there, he was not there.
That's right. So this says it was not until the defense sent a letter to the prosecution while the case was pending before a grand jury, notifying the Commonwealth that Colin Albert should be called as a witness, that the Commonwealth finally produced information that Colin Albert was indeed present at Brian Albert's home. Basically, this motion says we don't even know this kid existed.
Right.
And everybody else existed. So it's weird. So their argument is that every defendant is entitled to a third-party culprit defense. And
because really, if you're saying you're innocent, you are implying that somebody else did it.
Right.
Right? So
that the evidence...
There are instances when you aren't allowed to, but I mean, I think in this case, it's pretty clear that there's some evidence that would make a good argument. That's
right. And also they argue the evidence is admissible for the purposes of what's called a Bowdoin defense in Massachusetts that refers to a case in Massachusetts. And they also, of course, argue in here that the police never sufficiently investigated these third-party third-party culprits.
Okay.
All right. So this is important to know because this was the first motion argued at the hearing today. And Brennan argued that this is a distraction to the jury and that the defense provided no evidence of any of their claims in their opposition motion. They didn't provide any evidence that Brian Albert was a drunk. They didn't provide any evidence that he'd sucker punched police officers. Brian Albert, by the way, a highly decorated officer, as he said over and over again. He said, quote, a third party...
I love to see like a moderately decorated officer. When are they going to say that? Like, he was not just high. He's on his way. Okay, go ahead.
He said a third party culprit cases have people who have relationships to the scene or the crime or the deceased. And that this apparently doesn't. These people don't.
Doesn't he check off all three of those boxes?
They check off all three of those boxes.
Thanks for making our case.
And he claimed in his argument that Brian Albert was not at the scene of the death because it wasn't inside Brian Albert's house. It was on his lawn.
Then who was at the scene of the death? Okay. Yeah, what a stupid argument.
Yeah,
okay.
So that was the argument. Right. Essentially, it seems, as someone on Reddit said, if one only listened to Hank's argument, you'd think the defense is trying to point blame at three people who've never worked with the victim, never knew the victim, and couldn't ever have crossed paths in their entire life with the victim. That is how it sounded. And he talked about, of course, the distraction thing over and over and over again. He talked about besmirching these good people's names. So, he says questioning the police investigation of the issue is inappropriate. Questioning the police didn't investigate these three people. And he said, my favorite quote of this entire part of the argument is the police investigated at the scene. They didn't see any scratches on these people. They never saw any overturned furniture in the house. You know why?
They didn't go in the house.
They didn't go in the fucking house.
They didn't ask him to come out.
Right.
The fuck God, Jesus.
He also cited this media interview that Karen Read did with a pair of radio hosts on the Greg Hill show. Okay. They said they interviewed her and then they talked about it afterward on the show. She was not on the show. And he said that Karen Read tried to plant a rumor that Colin Albert was in a feud with John O'Keefe.
Okay.
And that the radio hosts were like, no, that's just gossip, blah, 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 blah. That is not what happened. What happened was, here's the quote. She, Karen Read, was very honest with us because a big story all over the internet was that John O'Keefe had reported Colin Albert for some drug activity before all this happened, and she said that story is completely false.
So it's the opposite of what Brennan is saying.
The opposite is true. She said, quote, that never happened. He did not report him for anything.
Oh, wow. Okay.
So anyway, this was the heart of Hank Brennan's argument.
Okay.
Now, David Yannetti argued this for Karen Read. David Yannetti, as you'll remember, is a very high-profile Boston defense attorney. He was the first attorney on the Karen Read case. And he called Hank Brennan, and I'll play this clip, a quote, gaslight.
You can't do this if it prejudices the Commonwealth. That's crazy. Every single time you introduce a third-party culprit defense, you are prejudicing the Commonwealth by definition. You're not going along with their theory of the case. Mr. Brennan's aggrieved that we would deign to present this defense. I would note, Judge, there's I believe a certain amount of gaslighting going on here in that on one side of his mouth he talks about he wants Ms. Read to have a fair trial. But we've spent weeks where he's just trying to knock out all our evidence, just limit everything. He's, I believe, acting more like a defense attorney than a prosecutor in that regard.
I love his phrase there that it's more like Hank Brennan is defending the Commonwealth than prosecuting a case.
The crazy thing is like all these recent motions by the Commonwealth just seem to be trying to take away every defense argument. Not evidence, but saying you can't argue that and you can't argue that and you can't argue that. And it's almost like, well, what? It's not their job to say, to answer the question, well, what would you like us to, our defense to be?
What do you think we should, how do you think we should do it, Hank?
Yeah. Anyway.
I just want to make a disclaimer. I have a tendency to call the Karen Read people by their last names as a journalist would. And then I say things like Hank. That is not intentional. I'm not trying to be like dismissive. Literally, it's the language of the internet that has like infiltrated my brain.
Right,
okay, so
right.
I'll try to do better. But David Yannetti argued this for Karen Read. He basically recited everything that was in that motion about the means, motive, and opportunity stuff. He started by saying Brian Albert was a mean drunk. Is a mean drunk. He was drunk.
There's means. Yeah.
He talked about him being a first responder, never coming outside. He talked about getting rid of the family member. He talked about Higgins' consciousness of guilt, all their consciousness of guilt. He talked about the photo where Colin had the scraped up knuckles. By the way, the prosecution claims is another photo of Colin from before the incident where he has those knuckles. And Yannetti said, not true, and we'll prove it. He said John O'Keefe had two black eyes, looking like he'd been punched in the face. There was no evidence that Colin Albert existed. He appears in no police reports, et cetera, et cetera. All of these men were present. Interestingly enough, there's a case that Hank Brennan cites in his motion. Yannetti says that case was overturned at the SJC, the Supreme Judicial Court of Massachusetts.
Oh, so he was citing a case that had been overturned.
Yes. You know why it was overturned?
Why?
Because the judge didn't allow a third-party culprit defense at the trial.
Jesus. Yeah, okay.
He also, in a totally baller move, cites a very relatable case that he tried, that he argued in front of the Supreme Judicial Court on appeal and then tried the second trial. So clearly that appeal worked. Yeah. He said, this is not just a tradition.
Your Honor, I don't want to say like I know a lot about this case, but yeah, okay.
Yeah. He's like, this is not just a tradition. It's the correct way to do a defense. Because Hank Brennan is like, I know it's a long tradition that he's like, it's not just a tradition. It's a proper defense.
Yeah.
The SJC ruled in another case that prior unrelated bad acts could have hearsay about third-party culprits, but Yannetti was like, we don't even want to bring in hearsay evidence about that stuff. So we're not even asking for as much as this case that relates did. Like, we're not even asking for that much.
Okay.
He talked about the blue wall over and over and over again. So his argument was compelling, it was concise, it was clear. I will say, Hank Brennan is repetitive and rambly. He just is. There's just no way to say it otherwise. Yannetti, who we've heard less from than Jackson in the trial process, although we did hear from him, is very articulate and very clear, and he was fired up today.
I will say that I find, like, objectively speaking, I do find that to be one of the weaknesses of the prosecution is that the oratory skills of the two prosecutors, very poor, it seems. Low energy, not very exciting or compelling, not demonstrative as far as like painting a picture. Like when I'm not being, like bias one way or the other, how I feel on it. I just feel like this is the A team.
Yeah.
You know,
exactly.
anyway. And they brought someone else in because you think, oh, he's the A team.
Remember
what
that article said, that no one else in the prosecutor's
no one else
office
really
wanted to do it.
And I can't figure out why.
So in Hank Brennan's rebuttal, you're not going to believe what he said.
What?
So he said, I'm just focusing on facts and case law.
This is all the same motion.
This is an important motion, the third-party culprit defense motion. He said, the federal investigation found nothing here. So it's improper to bring it in. It's essentially what he said.
Okay.
Yannetti got up because he got a chance to rebut that, and he was pissed. And he was just like, for Hank Brennan to cite a federal investigation that neither of us were involved in, that we do not know the outcome of because the feds have not said they have exonerated anyone, is completely inappropriate. And a plow driver saw the Ford Edge where the body was found at like 2-something in the morning. So that was the end of that. It was very fiery. Didn't really go too far beyond what the prosecution and defense said in their motions, but it was fun to hear him say it out loud.
Yeah, okay.
All right, next up, there's a motion filed by the Commonwealth that they want all the records from Unsolved Productions. You know who that is?
Is that the Max?
Yes.
Okay, right.
That's Terry Dunn Muir's company.
Okay.
By the way, the only reason I know who she is, of course, Kevin, is because we do the Netflix podcast, and I've interviewed her a couple of times.
Do you remember for what was it for?
Unsolved Mysteries.
Unsolved Mysteries.
She's the creator of the new series of Unsolved Mysteries, and
those
she
production companies bounce around doing a lot of different kinds of things. Yeah,
and remember, she worked on the original Unsolved Mysteries as well.
Okay.
So Hank Brennan said these are substantive records; they can be used to contradict Karen Read's statements, and that I spoke with Unsolved, and they're fine with giving them to us. Jackson stands up and says, this is literally the first time we are hearing about the Commonwealth speaking with these people, so we're completely unprepared to argue this. So that was the end of that.
Okay.
Bev, I guess, just kicked it down the road a little bit.
No,
right?
yeah, she never does that.
All right. This was the big one.
The big one. All right.
I need to explain this motion because I don't think we covered it on the readathon.
Okay.
Actually, I know we didn't. The Commonwealth filed a motion to use some of Karen Read's and David Yannetti's text messages with one another and break that attorney-client privilege because they claimed Karen herself waived it when she did interviews to the media where she cited what it was she said to her lawyer. Right. You know, he cites the Gretchen Voss interview, which the judge allowed. And basically he said, we don't want all of their communications. We only want communications that are contained in material the Commonwealth already has, aka Karen's phone dump. All right. So they want their texts close to the incident. They want texts from a few months later, stuff that they have. Okay.
So they physically have the data, but it's behind the Chinese wall. Because that's
a legal term, by the way.
That's right.
Anyone's worried.
Yeah, but there's a special team that goes through it, looks for attorney-client privilege stuff. They're separate from that. They redact it.
Yep.
And okay, yeah.
It's called the Taint Team, by the way.
Taint Team, there
which
you go.
Which is the funniest name.
Okay.
So there was a big conversation. This spurred a huge conversation in the online legal community and of the world about the fact that Hank Brennan was arguing to basically bust.
To pierce the
attorney-client privilege.
Yeah, okay, all right.
Now, I will say, as a concession, there is argument to be made for that because there are cases in which clients can waive that, and there are rare cases in which a client behaves in such a way with their lawyer publicly that has been talked about, that piercing of the thing. This case, though, spurred a lot of conversation with lawyers online, even anti-Karen Read lawyers saying this is unprecedented and completely inappropriate, and Hank Brennan, as a defense attorney, how will his clients ever trust him again? And how will anybody in the Commonwealth feel good about being defended and talking to their lawyer if they know that there's this precedent? Yeah. So what do you think about this motion?
Well, okay, this reminds me very much of Trump versus United States, where I should say United States versus Trump in the documents case, where they made a motion to pierce the attorney-client privilege because there is an exception when, I'm trying to remember the exact term, but if they believe that the attorney has acted in a criminal way,
if he's part of the criminal enterprise,
to further in furtherance of the crimes or whatever, then they can go in and that's what happened there because there was the allegation was that the former president had asked his attorney to go through and pluck out sensitive documents from the ones that we returned. So that was that. So, I mean, if there is no evidence or hinted evidence, well, a hint is a fishing term, but if there is no evidence that the attorney acted improperly, then you really have to say, well, did Karen Read actually waive the privilege by saying what she said to her lawyer?
Right.
It is such a long shot, and I think it's dangerous, but in these days, precedents are falling all over, but I just cannot imagine. I think that if Judge Cannoni were to grant this motion, this trial would be overturned in a fucking heartbeat.
Right.
Because this just seems like so beyond the pale. How did this work out?
Well, the good news is, Kevin, I have an answer to that conundrum for you. So Hank Brennan got up, basically cited everything that was in his motion in a very repetitive way. He cited the Gretchen Voss interview. He cited the Vanity Fair interview. He, talked about things that Karen had said publicly about what she said to her lawyer. Okay. Robert Alessi got up to argue this, and he was, again, fired up, just like David Edetti was fired up. He was basically yelling. The Commonwealth says, he said, it seeks to intrude on privileged conversations. Now, he points out that the comms they want, there's 2 sets of them. One is over 9 months old, and one is 5 months old. And that's her giving the interview to Vanity Fair, right? But they waited until less than 2 weeks before the start of the trial to bring this momentous, consequential motion. Courts have a dim view on this kind of thing, he said, and the Commonwealth never explains their delay. Then he went on to say, this should disturb every citizen of the Commonwealth, and it should unsettle every defense attorney in the Commonwealth. So he cites a SCOTUS case that overturned a conviction because of this kind of issue. And he said, dating from at least the age of Shakespeare, the attorney-client privilege is sacrosanct and has been sacrosanct in the Commonwealth since 1931. So the Commonwealth says in its motions for all of its propositions, they cite cases, and he says that even the case he cited supports the privilege. Once again, Hank Brennan misusing case law, says the defense, to support his argument.
Yeah.
So at the beginning of his argument, Alessi said there are 2 separate issues here, so I'm going to address one and then the other. He starts addressing the second issue, and Beverly Cannoni interrupts him.
Mr. Alessi, I'm going to stop you. I understand the Commonwealth's argument regarding waiver. I understand that the request is narrowly tailored. I'm not going to need to give you this information, Mr. Brennan. I don't even think it's appropriate for me to ask, so your motion is denied.
I understand the motion. I understand the Commonwealth's argument, Mr. Brennan, but I'm going to go ahead and deny this motion. So she was just
From the bench, said enough.
You don't need to talk anymore. She's like, excuse me, Mr. Alessi, but I'm just going to stop you there.
Because I'm really sick of hearing you talk, so I'm just gonna do everybody a favor.
Well, you know how much she cares about time.
Oh, fucking hell. Yes,
All right, so then there was the break.
It's all before lunch? Yeah, okay.
Yeah, then there was the break, and then they came back from the break, and they basically had this negotiation with the judge and the 2 sides about their jury questionnaire supplement that they both the Commonwealth and the defense had sent in supplemental jury voir dire questions that they wanted asked of the jurors. It was things like, the defense version of this question reads differently than the prosecution version of this question. I tend to like the prosecution version better for XYZ, and the defense would say something like, we have no problem with that. Or in one case, Jackson said, we actually want these separated into 2 questions instead of eliminating one. And what that question was is, do you tend to believe the testimony of cops, firefighters, first responders because of their jobs? And the second question he wanted to stay in was, do you definitely always believe cops? And Judge Cannoni said, I'm leaving that second question out, but I will ask it at sidebar, bench voir dire, if they answer affirmatively to the first question. So then Bev basically talked about how Judge Cannoni basically then talked about how she's going to go through this huge pile of jurors. More than 2,000 people have been called for this jury. So they now have to answer this longer questionnaire. And she said, collecting questionnaires from 200 or so people, which is how many make it every day. And then assuming during the first round of voir dire, we release some, so say there's 150 left. They're the ones who fill out the questionnaire. We then have to collect them, copy them, for me and then for both sides and then distribute them to you, that's like a 2-hour process at least. So what she wants to do is on Tuesday, have the first group come in, do that process, voir dire, panel voir dire, questionnaire, and then let them leave and come back the next morning. And then the next morning is
they basically do the homework.
Yeah. No, they're going to fill out the questionnaire and take it.
Right.
And then she's going to let them leave, and they're not going to make any decisions about these jurors that day. They'll do it the following day.
Okay. All right.
And then she'll bring it that following day. She'll bring the next group of jurors to the same process. So she wants to sort of roll this forward, which makes sense to me. Mm-hmm. Also, there's some motions they did not address today that will be addressed next week. And she said, is there anything that anyone needs to address now? And Brennan stands up, Hank Brennan, and says, we still haven't decided on ARCA. I have grave concerns about their discovery. Grave concerns.
ARCA. Yeah, okay.
So his entire argument is that he's gotten incomplete discovery about ARCA. He basically wants more discovery on why they're unbiased witnesses. And Alessi gets up and says, I have no idea what he's referring to about grave concerns, and he needs to tone it down with the hyperbole. I don't even know what he wants here, basically.
This has been this bickering has been going on for a while now between the attorneys here,
right.
And it is amping up
right.
Quite a bit. And I'm just waiting for one of them to say, shut the fuck up on this, right?
Right.
I'm waiting for one of them to sick their dog on somebody, right? So it's just...
Yeah. Another thing they talked about was they have received an argument around Dr. Welcher. So this was the expert that the Commonwealth wanted to use, who was the guy who said he fell backwards, all that stuff, and he had this huge slide presentation.
Yeah.
They agreed to winnow down the slide presentation, take out the things he wasn't qualified to speak on. Apparently they sent another 100+ slide presentation to the defense, along with megabytes of data that are so big they can't even open it. So the judge granted the defense 2 more days to go through that and counter-argue that whole thing. So finally, an interesting thing that came up process-wise is that Jackson asked during jury voir dire, can Karen Read have a wireless earpiece in so she can hear what's happening at the bench? So what happens in voir dire, Kevin, as you know, is there's a questioning of the whole panel, and then individual people come up and the judge questions them, and the lawyers usually stand there. And Judge Beverly Cannoni was like, Karen Read can come up to any sidebar she wants. She could just stand there. And Jackson's argument was, it's not cool for the potential jurors to have Karen Read be standing right there. That might present some issues. It could be problematic. And then he, proposed they do a wireless microphone headphone situation. Cannoni said she wants it in writing. She wants a proposal in writing, which she often says. I
haven't heard of that before. I mean, I've heard of there are situations for people with hearing impairments where they can, especially jurors sometimes, where they can wear sort of these like Walkman headphones so that they're plugged into the courtroom audio. But you're talking about audio that is not public.
Right.
I haven't heard of this before. Maybe attorneys have, but okay.
Yeah. Well, I don't know if it's something that he's done before in California. Who knows? But she's basically like, in Massachusetts, we don't do that. So I doubt she's going to allow this.
Yeah, it seems a little.
The final thing that I wanted to discuss today is that Brennan talked in the courtroom today about some new cell phone evidence they have, which it changes the timeline. It adds to the timeline of that night a little bit. The new thing, John O'Keefe's phone disconnects from the Lexus Bluetooth at 12:30 a.m.
Okay. By the way, this is the Commonwealth's bringing this in.
Yeah.
Okay.
So here's the new timeline. 12:21, John O'Keefe and Karen Read arrive at 34 Fairview. 12:21 to 12:24, John takes 80 steps. This is a combination of the data sets together, okay? Because, of course, the Commonwealth says he didn't take 80 steps. He was in the car. 12:22 to 12:24, John travels 3 floors. 12:29, Jen McCabe calls John O'Keefe and says, like, where are you or whatever. 12:30, John O'Keefe's phone disconnects from the Lexus Bluetooth. This is 2 things to me. One of 2 things. Either Karen Read drove away or he went in the house. Thoughts?
Yeah, I mean, okay, when you disconnect, well, I mean, it also could mean that he shut off his phone, which might be what
that's distance, because there was activity on his phone after that.
Right. Okay. Yeah. I'm just trying to come up with other things, but that most likely implies that there is distance now between the telephone and the car.
Right.
So, I mean, the Commonwealth might say, yeah, she struck him and then drove off. But but in order to like have a lot of faith in that data point, which is at 12:30 a.m., then you need to have faith in the other data points that says that John traveled 3 floors and then walked 80 steps.
Right.
And, all this happened. I mean, how do you like go from walking 80 steps away? Anybody try pacing this out?
Yeah.
Then going up, then climbing 3 sets of stairs?
Well,
up, down.
Interestingly,
down,
Kevin,
up, down. Yeah.
Interestingly, at 12:31 to 12:32, John O'Keefe takes 36 steps, travels 82 feet. Okay. So
yeah,
he's moving after his phone disconnects from
the
Karen.
car.
Right.
He's still moving after the car has left the area.
And remember, at 12:36, as stipulated by Nicholas Guarino, cop for the prosecution, Karen Read's phone connected to John O'Keefe's Wi-Fi.
At 12:36, Karen's phone connected
with John O'Keefe's Wi-Fi.
At his home.
At his home.
Oh, okay, yeah. Not at I can't believe I don't remember this Fairview.
Yeah. To me, this is proof that she was gone before anything happened to him.
Yeah.
And I've thought that for a long time. So I printed this out for you to help you out a little bit. All right. Here is the Google Maps directions from 34 Fairview to 1 Meadows Avenue. Now, keep in mind, all these maps always show people driving at speed limit, which nobody does.
Yeah.
So
there were weather considerations too, but okay.
Remember, I was going to say, this is a blizzard, so she probably wasn't driving 70. This is 2.3 miles away via Sherman Street, which I guess would require that she knew that route, which is a little back streety.
Yeah.
Which, remember, she didn't know where 34 Fairview was. So
right.
A lot of people
She probably said, take me home.
Right. There's a good chance she took this route, which is 2.6 miles. The shortest route takes 6 minutes. The route she may have taken takes 8, and the longest route takes 9 minutes. Now,
they're all between 2 and 3 miles.
Remember, the only thing I think you need to know here, John O'Keefe's phone disconnects from Karen's Lexus Bluetooth, and then 6 minutes later, her phone connects with his home Wi-Fi. That's a 6-minute window, and after the beginning of that window, John O'Keefe took more steps.
Yeah.
She was not there.
Yeah. I mean, if this is all accurate.
This is all accurate.
If this is in concrete, accurate, cannot be pierced, cannot be doubted, then it does seem to prove that after Karen drove away, John O'Keefe was still alive.
Yep. Or somebody was moving his phone. Which no one would be doing if she had hit him and he was lying on the ground. Right. Okay?
Right.
Interestingly, Jen McCabe says that she saw Karen Read pull away at 12:45.
Okay.
Clearly not true. She started texting John O'Keefe with all these quick text messages at 12:45. All right? And then that's when she says she saw Karen drive away. So her testimony, doesn't really match up with this. The missing library footage is from 12:37 to 12:39. Now, everybody kind of agrees that with these footages, it all depends on the timestamp that's on the video. So that little 37 to 39 could be 36 to 30 in real time, but their timestamp shows 37 to 39. That's the missing library footage that would have showed Karen Read gone, driving past the library on the way to John O'Keefe's house, and likely would have showed the condition of her taillight to some extent.
Right.
Rest of the footage is there. That piece of footage is missing. So anyway, this is the interesting stuff to me that kind of came up today, and I really want to thank the smart people of Reddit for doing things like assembling a timeline of things. I know all this stuff, but to see it visually is very, very helpful.
Yeah.
Let me just check one thing before we're gone for the day. I want to check and see if this decision has come out. Yeah, exactly.
Let's just assume that she's not going to grant this.
Here we go. All right, Kevin, breaking news. Judge Cannoni has denied Karen Read's motion to dismiss.
Yeah.
She also included a transcript with a dismissed juror that shows the conversation before the juror's dismissal on the day of closing argument. So we'll get into that next time. But as predicted, Judge Cannoni denied the motion to dismiss.
We're on.
High five, Kevin.
All right, yep.
That's it for the readathon today. What do you think?
Lots going on.
All right.
And when do we start? When's the trial? April 1st?
Next week on Tuesday. But who knows? Shit could go down before then, as it does. All right. See you next time.
Bye.
in crime media.